Welcome to today's course entitled Special Needs Trust for Individuals on the Autism Spectrum. This program is brought to you by Washington Trust Wealth Management. At this time, I would like to turn the call over to your hosts, Lisa M. Coutier, Lauren K. Drury, Anna Johnson, Kimberly I. McCarthy. Please go ahead.
Thank you very much. Hi, everyone. This is Kim McCarthy from Washington Trust Wealth Management. I'm the Chief Tax and Benefits Officer and Head of Client Service here, and I'm very happy that you're all with us. Today, as you heard, we're talking about special needs trust for individuals on the autism spectrum. And as you may have, one of the reasons you may have wanted to join this call, this webinar, is the idea of planning. If you have somebody, if you're either a professional or you have somebody on the spectrum in your life, it's hard to plan. Caregivers and loved ones of individuals on the spectrum often find it's very difficult to plan for their future. Either they're stuck in the day-to-day, some of them are DIY caregivers for the folks on the spectrum, and they're trying to either avoid or deal with those day-to-day crises that many of you, I'm sure, are familiar with. On the flip side, you don't know where you're going to be in the future. It's hard to predict when you have someone on the spectrum what your needs might be. So needs change over time, the impact changes over time, and the range of needs and challenges vary in a great deal. So with all that in mind, what we're trying to talk about here today and to give you some insight in is why would people on the spectrum benefit from special planning and how special needs trust can help. And to do that, to talk about that, we brought together a great panel for you today, who I'd like to introduce to you now. The first is Anna Johnson. She's the head of school at the Wolf School. She's been with the school for 21 years. She led the school since 2013. The Wolf School is a K-8 independent school for children who are complex learners with multiple learning differences, including children on the spectrum. And the school provides a unique educational environment with individualized academic programming following grade-level expectations, but with sensory processing support and social thinking skills immersed into the academic curriculum. Anna received her undergraduate and master's in teaching degrees from Brown University and her master's in elementary and middle school administration from Providence College. Next, we have Lisa Coutier. Lisa is a partner and executive committee member at Burns & Levinson LLP in Boston. Her practice includes litigation and dispute resolution relating to trusts, wills, guardianship, and conservatorships, and many complex and involved custody, parenting, divorce, and family issues. Lisa was previously the Assistant General Counsel for the Massachusetts Department of Mental Health and Department of Mental Retardation, and among other awards, she has been recognized with a Best Lawyers designation from 2010 through 2019, a Super Lawyers designation from 2005 to 2019, and a Top Women of Law recognition in 2019. Lisa is a graduate of Northeastern University and the Suffolk University Law School. And finally, we have my colleague, Lauren Drury. Lauren graduated from Case Western University Law School and practiced in trust and estates before she joined us here at Washington Trust Company. She is our Chief Fiduciary Officer, which means that everything related to the administration of estates and trusts, including special needs trusts, reports to Lauren. She reviews our trust documents, provides legal analysis for our internal operations relating to fiduciary accounts. She drafts our policies, procedures, and best practices for trust and estate administration. And most importantly, for this conversation, she meets with families, attorneys, and advisors who use corporate fiduciaries for trusts, including and especially special needs trusts. Lauren also works a lot with professionals like Anna and Lisa to develop and implement plans that support our clients, including people who set up special needs trusts and beneficiaries of special needs trusts. So with all that, I think we can get started. And what I'd like to do, if possible, is give everyone on the call a brief overview of autism spectrum disorder in general, a little sort of understanding of what we're talking about, defining our terms, and just what it means for somebody who is on the spectrum and their family when you get that diagnosis. So, Anna, could I turn it over to you to give us a little bit of an overview, please?
Sure, thank you so much. I think I'll start with a definition of autism spectrum disorder, which is a developmental disability that can cause significant social communication and behavioral challenges. Back in 2013, the American Psychiatric Association merged 4 different distinct diagnoses of autism into one overarching umbrella, which created this one diagnosis of autism spectrum disorder. Previously, the diagnoses were autistic disorder, childhood disintegrative disorder, Asperger's syndrome, and pervasive developmental disorder. So now we sort of have this one spectrum called autism spectrum disorder, and I think it's important to know that when we talk about autism spectrum disorder, it's, there's a wide spectrum, so it's varying degrees, and, there's not one type of autism, but many subtypes. So that just is helpful sort of in thinking about how we talk about, children and young adults with autism spectrum disorder. How ASD presents itself is reflected in a number of characteristics and different diagnostic criteria, and that includes social skills deficits, so things like avoiding eye contact or having difficulty understanding sort of very just routine feelings themselves or feelings in others, repetitive behaviors, so they don't like, they don't like change in their daily lives. They, stick to very routine sort of functioning throughout their day, throughout their lives. Speech delays, so a lot of delayed language could come into play. Communication challenges, for sure, would be a part of that. And then emotional dysregulation, so really intense reactions often to sounds or smells and tastes, textures, light, and even colors. So, the Centers for Disease Control in 2020, they estimated about 1 in 54 children in the U.S. today are diagnosed with ASD. And about 10 years ago, it was more like 1 in 59. So it's about a 10% increase in the prevalence of autism at this time.
And Anna, would you say that is due to like greater understanding, or maybe sort of, which is a good thing, maybe a little bit of a less stigma, so that people are going and asking about it more? Do you think that's part of it?
I think so. I think that it's definitely being diagnosed more, and educators and evaluators, and it's just pediatricians. They're more aware of this diagnosis, and just being able to diagnose it early really does have a really positive impact, on treatment. And so I think that they, doctors are really in those initial, when they're meeting their milestones or not meeting their milestones as early as age 2 or 3. I think pediatricians especially are sort of the key, and and early educators in those early childhood programs are really key in sort of helping families to kind of come, to a diagnosis or to get evaluated, because some of these sort of characteristics or criteria may be, sticking out to them in some way. So yeah, I think it's definitely being diagnosed more.
Yeah, and if I could go back 1 second, you listed a lot of different types of things that people could see in folks on the spectrum, different challenges that they might have. And before all the diagnoses were merged, there were things like, for example, Asperger's syndrome would have been called out as one, and things like that. But is it just that each of those little sort of subcategories has their own sort of set of symptoms, or is it even within there, there's a range of different impacts and challenges and things like that within individuals diagnosed with those being on the spectrum? Even within, say, Asperger's syndrome, you could be at one end or another end of a range.
Exactly. Yeah, it's definitely much, the ASD diagnosis is a much more overarching umbrella, but within there, there are common characteristics on the spectrum and varying degrees of the spectrum where kids or young adults or into adulthood would sort of fall. And I think that's sort of where they got to that autism spectrum disorder, because it is hard to sort of, there's a lot of characteristics within each of those subcategories that, some have sort sort of more difficulty with in certain areas than others, So they don't, and it's not a cookie cutter, one size fits all. It's really looking at the individual, person, and really determining sort of what are their strengths, what are their challenges, and what are they having difficulty with, and what support do they need long term. So there really is a wide range.
And then if I'm, before I let you go on, I'm sorry, I keep asking you all these questions.
No, that's fine.
But in addition to spectrum disorders, if I'm not mistaken, there's other sort of comorbidities that you see a lot with kids who do fall on the spectrum, like, for example, anxiety or depression or things like that.
Yep.
So that's another thing that folks may not know, that when you are diagnosed as being on the spectrum, if I'm correct with this, there's oftentimes additional other issues that those kids and their families have to deal with.
Yes, absolutely. Comorbid diagnoses are very common with folks on the spectrum. So, sensory sensitivities, a lot of gastrointestinal disorders, sleep difficulties, and then mental health challenges for sure, like anxiety and depression and attention issues. Executive function challenges are also something that, children and young adults on the spectrum have a difficult time with. So yes, absolutely, lots of comorbidities that follow along with the autism spectrum diagnosis.
Yeah, great. Thank you for that. So I don't know I don't know if I cut you off there, Anna. Did you have more on that before I move on?
Yeah, I mean, just sort of in terms of thinking about just with long-term planning, related to sort of what we're talking about today, I think, the kind of what we've been saying along here is the learning and thinking and problem-solving ability of people with ASD really ranges from, gifted to severely impaired. And I think some people with ASD need significant support in their daily lives, and some need a lot less. And some of them even live entirely independently. So I think, again, this is a wide spectrum we're talking about, and each person sort of has their own unique strengths and challenges. So I think any long-term planning needs to really have flexibility, and it needs to be individualized to the child or young adult or, person that's diagnosed with ASD. There's no set test to diagnose autism, no specific test, but when doctors are looking at behavior and child's development early on to determine the diagnosis, they sort of see those signs of autism, which usually can appear around ages 2 or 3, and some associated developmental delays can even appear earlier, and can often be diagnosed as early as even 18 months. So, early on, if we can sort of get those diagnoses and create a plan, a long-term plan, and including, behavioral interventions and early intervention with social skills training and occupational therapy and speech therapy, and sometimes medication is involved. So there's a lot of those, factors early on that come into play that are going to help to set us up for success with these long-term plans. But that, like I said, they can start as early as 18 months to 2 or 3 years. So.
Yeah, and like you said, there's no one sort of diagnostic test or anything, but there's also no cure or treatment in that sort of way. So if I'm understanding this correctly, somebody could improve the issues that they face in their life could lessen, or it might not happen, and it's hard to know. I mean, obviously getting in there early and making these changes and providing supports and treatments will help. But am I right in saying that it's not clear, when you get diagnosed at, say, 2, it's not clear what your life path is going to look like?
Exactly. No, everyone is sort of different and on an individual trajectory, I think, in that way. And so I think, definitely early intervention, definitely early diagnosis is key. But there's interventions that you can, make all along the way. And I think that's sort of part of developing these plans, as these individuals become older, in terms of what that's going to look like and what their path sort of is going to, how their path is going to develop, it's definitely varies, by individual.
Yep, and I think that leads us really into our next area we're going to talk about, how planning would help, is to talk about some of those interventions and costs that, what are the types of things that you would expect somebody who has a child or grandchild diagnosed on the spectrum to need to do over the course of their lives that might be in addition to what they would do for any child? Like what are some of the things that they might need?
Right. Yeah, definitely increased cost overall, I would say, especially, related to individuals with ASD, and just thinking about the long term, like what would they need, what special planning do they need sort of at whatever age they get that diagnosis. The bulk of the costs, have to do with just special services provided for the ASD individual. So that could be specialized schools or, a private school versus sending them to a public school, or additional, services, speech services and social skills groups and occupational therapy groups that, these children are going to need as soon as they're diagnosed all the way through. Sometimes residential programs are really successful, and, a boarding school, which, can be significantly more expensive than a day school. So that, those special services that are required to support the ASD individual are really important at that, early age. Sometimes just lost wages related to increased demands of parents, parents who have to sort of become the primary caregiver and may not be able to work because the caring for their ASD individual is going to become, the main part of their focus and their job, essentially. And I would say cost increase as the child or young adult is more involved, which again is why a special needs trust needs to be established early on and needs to have flexibility now, but also especially in the future. So, those are a few things. I think early intervention programs, when children are diagnosed early, before 3 years old, there's early intervention programs, through school that can be accessed. And then, certainly with a child with ASD, they have so many unique and, individual skills and talents. You're always looking to sort of, highlight those and provide support and resources to, to strengthen those areas, because so much of what they have to deal with is challenging. Those special interests and hobbies and social skills groups, if they like acting, getting them involved in acting classes or music or cooking, really trying to engage them in activities that are high interest for them, and you want to kind of keep them engaged and also provide social opportunities for them to kind of get to work on those sort of social skill deficits and social communication difficulties. And then testing and evaluations. I mean, there's a good neuropsychological evaluation to either help with diagnosing a child, or just long term, you kind of do those every 3 years or so, just as they're going through school. Those can be up to $4,000, $5,000 that you have to pay to have one of those evaluations done. And so, those are lots of increased costs, I think, as you're sort of navigating an individual diagnosed with ASD.
Yeah, and I think you had mentioned before, you and I had talked about this, that if you're going to some of the sort of better testing facilities, a lot of them are not covered by insurance, and that in order to access benefits, you have to renew those because as you had mentioned earlier, right, the impacts change, the child changes, and so that has to be updated in order for the child to continue to qualify for school services, maybe a plan at school or things like that, or any sort of benefits. Is that right?
Absolutely. Yep. You're completely right. Yep. For sure. Yeah. Not a lot of times these services in general, even the social skills groups and even sometimes occupational therapy and speech pathology. Speech therapy, they're not covered by insurance, so you're paying for a lot of that out of pocket. There's also sometimes the need for a psychologist on board or a psychiatrist on board, and a lot of those providers don't take insurance. So there's a lot of out-of-pocket expenses around that to provide really solid supportive care for your child and young adult.
Absolutely. And I think when you were talking a little while ago, you mentioned something about the impact on career or income for parents, lost wages, time out of work, and not all of that is covered either. And Lisa, I think in your practice, you deal with a lot of these sort of complicated parentage type issues. Maybe you want to comment briefly on that?
Absolutely. Thank you. We were talking a lot about the expenses of a child and the needs of a child, but we're talking also about a family structure and the needs of the family. When you're looking at the needs of the family, it's important to recognize that there's an inherent conflict here. Individuals who have needs very often are an expensive drain on family resources that may be limited to begin with. I'll never forget a client of mine who came to me and said, you know, my child had to spend, unfortunately, a little period of time in a psychiatric hospital and ended up with a new medication to help some impulse control disorder that was related to some sensory integration. And the medication had a copay. The copay was extraordinarily expensive, and the hospital had no idea that that was going to happen when they made the recommendation for this medication. And the client went to pick up the medication from the pharmacy and called me and said, I had to make a choice whether or not to pick up this medication. It literally was the same price as our monthly family food budget. And that just gives people an idea of what we're talking about here. This is expensive. It's so important to have predictability. We were talking earlier, Anna was talking about planning. Planning is so important. And so part of the reason that we're all coming together right now to talk about this is because the family unit and the family structure can be destabilized when you have a child who has special needs. Especially now, you know, we're all speaking during a COVID pandemic where life is ever more expensive in order to keep yourself safe. And we're looking after children, some of whom are in school full-time on campus, and some of whom are at home learning remotely, and that takes time from the family to help the child to get educated remotely. And some of those children are on hybrid programs where they're remote part of the time and they are in person on campus part of the time, and then perhaps one of the school campuses has a COVID exposure, somebody tests positive, and suddenly for a week everybody is remote. And it causes a lot of financial disruption to families. Families should never have to be, and unfortunately are, in a competitive position where sometimes they're wondering, am I saving for my retirement, or am I funding these present needs? Am I saving for other children's college education, or am I funding these present-day needs for this child? And that is a terrible conflict to have. So what we're trying to do here, this group of people, these experts on the line, on our podcast here, the webinar, is to develop some strategic thinking in advance so that we can take that pressure off of families. You know, it's ever worse if a family ends up with a divorce situation. And I'll tell you, one of the greatest causes for divorce in Massachusetts is not only financial issues, it's not only indiscretions and conduct issues in the marriage. One of the largest issues is having a child who has special needs. It will bring down a marriage. It is very difficult for families, and for couples, it's one of those forces that presses on a couple in a very difficult way. And when you're dealing with a divorce, you're dealing with potentially having two households. So now, in addition to the financial impact in one household, you're now dealing with it in two households. You're dealing potentially with transitions of parenting time with the child. So the child is living in two homes and moving back and forth, and that can create further disruption, further destabilization. And the best thing that people can do for their families, given all of this neediness and potential destabilization, is to do the planning that you, Kim, and you, Anna, were talking about, so that you can have predictability. You need to have predictability, and that's the most critical thing. You should never have your own family members competing for limited resources.
Yeah, that's a good. Those are all very good points. Thank you, Lisa. And bringing it to the autism spectrum disorder in specific, something you mentioned earlier, Anna, that I just wanted to go back to was about the special hobbies and ideas, because some people might think, oh, you know, your kid does karate, your kid does this, and you know, if there's either an issue with money or something, maybe you just don't do that. But these types of interests for folks on the spectrum are not just like a hobby. It's a lot more than that. So it's hard to get rid of that, regardless of how much tension it's putting on the family. Could you speak a little bit to that, Anna, about those special interests and why? I think you touched briefly on it, why it's so important and why people are probably going to need to fund those regardless.
Yeah, I mean, I think that it sort of speaks to the impact of the, on the life of a young adult with ASD just in general. I mean, a lot of those hobbies and special interests that you're trying to develop when they're younger are really become their, either areas where they might potentially be able to get some kind of a job in those areas, even if it's acting and they're working backstage to help be a stagehand, or, you're trying to find those specific areas of interest that can sort of facilitate and help foster something productive as they become older. I mean, and leisure time activities. I mean, they don't, sometimes, folks with ASD have very limited interests, and, so you're trying to expand some of those interests and get them interested in different things, but sometimes that doesn't necessarily work. So you're sort of facilitating the things that they really do express interest in and are high interest areas for them, so that they can, when they are on their own, or able to live, possibly in a supported environment, but semi-independently, that they have activities that they can gravitate to and do on their own, so that, they have some productive use of time. I mean, the fact of the matter is there's high rates of unemployment or underemployment. Half of young adults with ASD are not employed or not in college, even if they have average to above average cognitive potential or intelligence. There's decreased participation in education beyond high school. A majority of them continue to live with family members or relatives. Some young adults with ASD can live independently, and others have severe disabilities and require lifelong care and support. So there's always, a need for longer lifetime support. That possibility is going to always be there. There's limited opportunities for young adults for social activities. There's statistics that say nearly 40% of young adults with ASD spend little or no time with friends. So, all of these aspects and, the symptoms of ASD, the behaviors, all the co-occurring health conditions, they all can impact their ability to function in the community. So, investing money in some of these areas is critical so that they can live a, semi-independent and at least a happy life.
Yeah, and I appreciate that, because we originally were starting to talk about when they were little babies and their schooling, but it's important for folks to know that this is something that lasts into young adulthood and really for your entire life, and that even for, and I think you mentioned it, and I would just want to underscore that it doesn't matter if a person on the spectrum is smart or has a lot of talent. Right. There are a lot of reasons why in the conventional world they may not be able to be successful, whether it's, social anxiety or sensory issues or depression or a lot of different things. So they can try hard, but they may not always be able, regardless of how hard they try, they may not be able to be successful in a conventional way, or even meet the sort of expectations of what they were used to with their family, as sort of that style of living.
Exactly. Yes.
Yeah. Yep. And Lisa, did you want to comment on that as well?
Sure. I'm actually happy to comment a little bit about emancipation, too, because what we're talking about is whether or not a child with autism spectrum disorder is going to launch, and to what extent can they. And the autism spectrum disorder is so all-inclusive that we've got to remember that each child is different, and each child's trajectory is different. And as children age out of childhood and into adulthood, nobody's trajectory is the same. It's a different trajectory, but there are issues that parents worry about as their children start to hit age 16 and 17 and 18. They're thinking about emancipation, and the parents are not sure to what extent they're going to have to provide lifetime support. Having special needs trust is one way that we can arrange to make sure that a child who's aging into adulthood continues to have an enriched life, a supported life, and a life that enables them to be productive to whatever extent is possible without having to have need and want for basic necessities of life. So the type of trust planning that we are going to be talking about is going to promote an enriched, productive life whether or not the child emancipates in a factual way. By law, they will. So when the child reaches 18 years of age, that child, is factually and legally emancipated, even if they can't actually manage their own affairs, earn money, go to college. And that's the fact whether or not you're divorced or still in an intact family. But I do want to mention one nuance that relates to the child's need for lifetime support in a context where the parents have divorced. It's a nuance in the law. The law says that upon emancipation of a child, the child doesn't have to be supported by the parents, and in fact that's reflected in our marital law and our divorce law in particular. Child support in Massachusetts, emancipation, and that's usually at age 18. However, if the child is full-time enrolled in college, then support could last beyond that, especially if the child is principally dependent on a parent. Then there could be child support that's paid over to the custodial parent, the parent on whom the child is principally dependent, and that child support could be payable till age 21 or 23 or whatever age is decided upon within a separation agreement, a marital separation agreement, if the parties have decided not to follow strictly the statute. And then the question happens, what happens after, years long after the divorce, if child support ends and the child is still not able to support themselves? And our law has flip-flopped back and forth. We had the Feinberg versus Diamond case back in 1979. And by the way, if anybody listening and registered today wants citations or wants information, anybody's always welcome to reach out to me at any time, and I'm happy to help. But the Feinberg versus Diamond case said that parents have a continuing obligation to support their dependent and needy children. And that was back in 1979. Since then, in the intervening, 30, 40 years, we've had a series of different case law that has flip-flopped. It's shown the court flip-flopping on this very issue. And most recently, just about 4 or 5 years ago, the Veda versus Veda case was decided, where the court said no. Parents don't have that continuing obligation to support a child who has special needs, whatever those needs are, whether it's autism spectrum disorder or any other physical or cognitive or mental health need. The court said no, unless the child is under guardianship or conservatorship, and as a result of the disability is unable to support themselves. And so the converse to that is also true, although the court didn't decide the converse, but the converse proposition is if a child is under guardianship and conservatorship and ages into statutory emancipation and is a child of a divorced couple, and the separation agreement ends child support, the question becomes, are the parents now responsible for the support of the child? And that case has not yet made it up to our appellate court. It has not yet made it to the SJC. I would love to be the person to bring it up to that court, because it's an interesting question whether there's a continuing obligation of support. But all of this is secondary to the main issue, which is what brings us together to discuss and to educate our registrants, which is every child should be supported with a special needs trust that is well-crafted, well-conceived, well-planned, and that has a very well-planned trustee or trustees. Because if you have that, then a lot of these issues will fall to the wayside. And if you're doing your special needs trust planning in the context of your divorce or in the context of post-divorce modification of child support, then you need to be with financial advisors, wealth managers, and lawyers who can provide the kind of expertise that will let you put provisions into that separation agreement or that modification agreement that speak to a transition away from child support and towards the funding of a special needs trust. In so doing, you can have your payor be relieved of the child support obligation. You can have the recipient feeling relieved because a special needs trust is being funded. And who wins? The child.
Yep, absolutely. Yeah, Lauren, did you have a question?
I did. So, Lisa, while you were talking about that, it kind of brought up a question in my head. And we are going to get to the special needs trust planning, but specifically here we're talking about planning for a third-party settled special needs trust. So just so that everybody on the panel and out there in webinar world, all of you, we're talking about a trust that does not have payback provisions to the state and which a parent or other relative or friend can fund to the benefit of the child, which will give them funds while they're still eligible if they need to receive governmental aid. So I just want to kind of throw a quick definition out there because we're getting ahead of ourselves. But Lisa, what you were just talking about was fascinating to me because though I and Washington Trust operate as a professional trustee and we see a lot of that and a lot of times we're inheriting plans after the fact, it got me thinking when you were just speaking about, do you see a lot of divorce settlements that are requiring, A, that a special needs trust be mandated in both parents' estate plans for future funding upon their passing, and is that a possibility? And I apologize if it's not. I'm completely ignorant on divorce law. Thank you.
But I'm delighted to have that conversation with you. I think it's very timely and very appropriate. And the answer to the question of whether or not I see that mandate that a special needs trust be prepared as part of one's estate plan and whether that mandate is contained in the divorce separation agreement, the answer to that question is only once in a while, and that's why I'm speaking about this topic as much as I possibly can, because it is an untapped resource, an unknown strategy, and it's one that can settle a divorce. And so, you know, this is I feel like I'm always on the soapbox when I do my presentations for people. This is the way out of a divorce controversy. If you take the funds that the parents are fighting about and you start thinking about funding a special needs trust, and if you were to contain in that separation agreement a mandate for the funding of a third-party special needs trust, then yes, that would probably resolve a lot of divorces and save a lot of lawyers' fees and a lot of controversy and acrimony. And again, you know, the person who would win here would be the child. So I think it's important, you know, especially for people like us in wealth management, trust management, financial advising, legal advising. It's up to us to spread the news, and to those people who are registered and listening to us, to let other people know that there are some unique opportunities and some unique strategies that can really promote the interests of the child and the family without pitting them in competition against each other. For exactly that reason, thanks for asking that question.
Yeah, and I have one follow-up to that, too. Then could you also, I'm getting excited now because I'm thinking about the way we can counsel our clients here, but is there an opportunity you would see where possibly in a divorce that you could possibly settle that's not only is that a mandate, but that there would be a life insurance and policy in place for a set number of years that would also fund that special needs trust? So kind of,
you know, life insurance is the other untapped resource. Absolutely. That is one. You know, when I meet with clients for estate planning or divorce work, and I bring up life insurance, I don't think that my clients understand what a valuable resource life insurance is. They're thinking about their death, and that's not really all that it can be used for. Life insurance can provide a level of security and a level of funding. It can be a funding mechanism that is, I think, terribly untapped. I think you've just identified two really phenomenal strategies that can be used for families who are concerned about gaining as much predictability as possible in a situation that is absolutely unknowable and unpredictable.
Right, because that's what I'm sorry, Kim.
No, that's all right. No, I think it's great. Go ahead.
No, it's just because that's what I was thinking about, is that even the best intentioned plan, even if they said, yes, you're going to fund the special needs trust as part of the settlement, but then mom or dad dies a few years in, and as we know, maintaining an ASD individual or any special needs individual can be costly. All of a sudden, that child support or that piece is pulled out of the equation.
Right.
And I think that even the best intentions in that settlement agreement could maybe be solved with a certain amount of even like a term insurance policy or something along those lines. That's my final thought on that.
We do that in my separation agreements for my clients when I'm handling a divorce. Routinely, the payor, the wealthier of the spouse, is asked to get a life insurance policy to ensure obligations, and that's obligations not only for child support but also potentially for alimony. So we do use life insurance for that, but I think there's also the unique and very viable use that you're mentioning, which is for the funding of a special needs trust. And that's something that really requires a lot of exploration and discussion so that our clients, our shared clients, will have the benefit of our shared advice and expertise on that very issue.
So I think this is very, very interesting, and I think it's also something I haven't heard before, so I'm really excited to share it with everybody who's online. But if we could just step back 1 second to tell everybody about Special Needs Trust in case they don't know about it, because we're all excited about this, like nerding out about how we're going to fund them. But let's talk just a few minutes about what they are and what they can and can't do and how they can be helpful. And then we can go back probably to talking about unique and different situations where we can fund them. So if you wouldn't mind, I'm going to turn it over to Lisa for a minute again and see if we can talk about, I had a slide up a second ago that talked about why we would do it. And I think at this point we kind of know why we're going to have a special needs trust. It can, to the extent someone on the spectrum has a significant enough disability to warrant governmental benefits, it can provide protection for those benefits. It can pass and protect assets, and we were talking a little while ago about why some folks on the spectrum might not be good. I mean, a lot of people don't want to just give their kids money outright for spendthrift reasons, like maybe they're not good with money, maybe they get unduly pressured by friends, maybe they are not financially savvy. All of those things are to the 10th degree when you're talking about folks on the spectrum. So that's another reason. And then there's also the fact of structure and flexibility, which I think we're going to come back to at the end to talk about how, and I'm going to bring Anna back in after we talk about the technical stuff to talk about why having a structure, flexibility, knowing your trustee, knowing your team, we're going to talk about that at the end of our seminar, about how important that is, particularly for folks on the spectrum. But for right now, could we just go into the overview, which is, comparing things like, let's start with the first, Lauren already mentioned third party. Let's talk about first party versus third party trust and what that means for folks and what the difference is.
Yeah, I'm glad to discuss that. It's a technical issue, but I'm going to make it understandable to the extent that I can. There are two types of special needs trust. One is called a first party trust. I refer to it sometimes as a self-settled trust, and the other is a third-party trust. So let me describe the two. A first party is a self-settled trust, meaning that I am setting it up with my own money, or my son, I'm going to set it up for my son with my son's own money. It's self-settled because we're using our own money. We become the beneficiary of the trust with our own money. And when you are doing that in order to receive government benefits, when you're putting your own money into a trust, or when we're taking our children's own money, their money, not ours, when we're taking their money and putting it into a trust, a special needs trust, in order to sooner qualify for mass health and the fine network of many Medicaid and Mass Health funded services and supports that really are not accessible in any other way than through Mass Health and Medicaid waivers, then once you're taking your money and you're putting it into a trust for yourself to sooner qualify for the government to pay for you, then the government wants to make sure that you're not just putting your money in a trust so that you're not going to pay your own way, so to speak. The government wants to make sure that they get a cut in this somehow. And so the policy is that if you put your money into a trust to sooner qualify for the government to pay your way instead of paying it out of your own assets, if you're not going to spend down your own money on your care and services and supports, but instead you want the government to do so, and if you want the government to pay you cash too in the way of SSI, then the theory here is that the government wants a slice of this at the very end. And so what that means is that if you're going to take your big personal injury settlement, or you're going to take a big inheritance, or you're taking money out of 529s, out of UTMA accounts, custodial accounts for kids, you're taking all of their, money that they have been gifted by grandparents and by family members at various times, and you're putting those funds into a special needs trust, then it needs to be set up as a self-settled first-party trust with a provision in it that is a payback or clawback provision. And what I mean by that is that there'll be a statement in the trust that upon the death of the beneficiary, upon your death, if you are the person who's using your own funds to establish your own trust with you as a beneficiary, on the death of that beneficiary, the first person who receives anything that's left over, any money left over in that trust, is the Commonwealth of Massachusetts to reimburse it for amounts that it might have paid for your care. And again, the theory here, the public policy is, if you're going to take your big personal injury settlement or your inheritance or your own money, and you're going to lock it up in a trust and then ask the government to pay for your care and ask the government for cash every month, then the government wants to know, the government says, okay, but we just want to know that on your death we have an estate recovery claim. So that is the gotcha with your self-settled trust. If you're putting the money, if you're putting your own money into a trust to sooner qualify, you need to recognize that you're going to be paying, you're going to be reimbursing the Commonwealth after the end of your life. A third-party trust is quite different.
Lisa, I'm sorry. Could I just stop you for 1 second? I just want to make sure all
Sure.
the non-lawyers out there understand, because we talked about your money, right? So your money doesn't mean money that came necessarily out of your pocket. It's stuff you're entitled to, because you mentioned about a personal injury settlement, but also an inheritance or an UTMA or UTMA account. Once you have sort of control over that money, even if it was provided by a third party, it's your money. That's what I just want to make sure everybody understands that.
Absolutely, and I'm going to give a real life example so that I can kind of nail that point home. And thank you so much for chiming in with that, because I want to make sure that people do understand the technicality here. Many times people, we all do. We have children, and when our children are born, family members start to send over cash, or they send over checks, and at every birthday there's a check, and every holiday there's a check, and it may just be $10 or $20, or maybe it's a significant gift. Maybe there are relatives in the family, maybe there's some family wealth, and money is being sent, and the parents do the right thing, and they set up UTMA accounts, Uniform Transfer to Minor Act accounts, or custodial accounts, or some kind of accounts for their children, or 529s, or perhaps there's just an account that grandmother has established for this young child so that they've got money in the future, maybe for college or whatever it is, for expenses, for living expenses. But we tend to give money to children and to families and parents are good intentioned, and they put those funds into the child's name as they should. It's money for the child. And then one day they have this difficult realization that their child may never be able to manage those accounts themselves, that as a result of autism spectrum disorder, those children may not be able to make use of those funds on their own, and that somebody is going to have to manage those dollars for them, and that on their 18th or 21st birthday, those assets are going to become accessible to now a young adult who does not have the capacity, intellectually, emotionally, or otherwise, to manage the level of assets that are sitting in his or her name. It's those assets that we're talking about with a first-party trust, with a self-settled trust. We're talking about parents being proactive, planning for predictability, and taking all those assets when they have that difficult realization, when they realize that their child might not be self-supporting and that those funds might be at risk, or that third parties might be exploiting this individual in the future, and that the funds may be at risk for exploitation, and that your child, as he or she grows older, may be vulnerable to the exploitation of third parties. So parents, if they're proactive, might take those funds and come to their lawyer or their wealth manager or their trust company and say, we need to take these funds and put them into a special needs trust. That's when we say use a first-party trust, because the funds are titled to the child who is going to become the beneficiary of the trust. That's the first-party trust.
Great.
Would you like me to move over to party?
Yeah, exactly. Let's talk about this. So first-party trusts are your own money, and because you're using your own money, the government's going to take their claw back at the end because they're providing you with benefits. So what about the third-party trust? Let's talk a little bit about that.
Precisely, thank you. So a third-party trust is just a wonderful, lovely thing. You know, we should all be so lucky to have clients who can establish third-party trusts. They are blessings, especially in a time like this. A third-party trust is a trust by which a family member takes their own money and establishes a trust for somebody else. So this, for example, could be grandma wants to establish a special needs trust for grandson. That is a gift. That is a beautiful, compassionate thing. And so sometimes there are family members who are doing their own estate planning, and they're thinking, I would love to leave my assets to my children, to my grandchildren, to my nieces, to my nephews, whoever it may be, but I know that one or two of my children may never actually be able to manage assets on their own. They're going to need a trustee. And maybe what I should be doing is talking to my trusted advisors about leaving these assets not in just any trust and not as an outright cash inheritance, but perhaps putting those assets into a third-party special needs trust, which will protect the family wealth. It protects wealth. It protects the child. It's a way of taking money from other family members and putting it into a trust for an individual who will need it in the future to enhance their life and for productivity and for enrichment. Now, with a third-party trust, the beauty of it is that there is no payback provision. There's no clawback provision. What I'm talking about is that because this was not funds that were used in order to sooner qualify an individual who would have otherwise had to spend down their own money towards different services and supports and otherwise have a payback. What we're talking about here is because the money was a gift, you don't have to reimburse the Commonwealth of Massachusetts. There does not have to be a clawback provision. And on the death of the beneficiary, who inherits it? Whomever you nominate. It's not going to be the Commonwealth of Massachusetts. in a payback provision. And that's the beauty of these two. And so before I even go further, I just want to make one note here for us, a footnote for us to remember to come back to. There is a strategy for which trust should be used first. And we'll talk about that going forward, but I want to just have everybody footnote that for some families, they're lucky enough and fortuitous enough and provident enough to have planned to have a self-settled trust with the assets that used to be standing in the name of the individual with the autism spectrum disorder, and a third-party trust that was established by family members. And you don't want to commingle those funds. You don't want to take the inheritance and put it into the first-party trust, and you don't want to take your own, the individual's own money and throw it into the third-party trust. You want to keep them separate for sure and not commingle and not cross over. It's technical. Your lawyer, your wealth manager, your trust advisor can help you, but it has to be kept segregated, and we will be instructing you before the end of this hour on strategies to make sure that you are spending the right trust first and preserving the correct trust for the future.
So Lisa and Lauren, too, I just wanted to ask this question. So we talked about self-settled trust, where the money comes from for those. Third-party trust could be a gift. Assuming the trust is drafted this way, can people add to one or the other? I assume you'd want to put the money in the third party versus the first party. And
yes, I'm doing this right now, actually. I've got a client who's doing some special needs trust planning, and there's a concern that her own relatives who are aging, and it's a concern right now because we're dealing with a pandemic. The COVID pandemic is really so unfair and is causing a lot of death in the world, and so people are doing a lot of estate planning with me right now, and one of the concerns is that we want to make sure that the third-party trust that my client is establishing for her daughter is also going to be a useful vehicle so that she can tell her mother and father in their estate planning work that they're doing to nominate her third-party trust. So keep in mind here, when I talk about commingling, we're not violating any commingling rules here. What we're doing is we're taking the third-party trust that was established by the mother of the child who has autism spectrum disorder, and we're telling the grandparents to fund the same trust that the mother's creating in their own estate plan. So the grandparents' estate plan will say, I leave assets to Lisa and Anna and Kim, but the assets that were to go to John should go, instead of being outright, they should go into the special needs trust that my daughter set up for my grandson. It would be that situation. You're directing the path, you're directing traffic to make sure that the family wealth is protected.
And Kim, I just want to put a follow-up on that as well, and thank you, Lisa, is that also we see third-party settled trusts used as a recipient for annual gifting. So if you have a family who is well off enough that they're taking advantage of the annual gifting exemptions and doing, I believe it's $15,000 right now, doing their $15,000 a year, $30,000 per couple. If they're doing that for all their other nieces and nephews, all their other children, we see a lot of times that gifting going into the third-party trust as well. So lifetime funding to take advantage of the exemption.
Yep, absolutely. And Lisa, you both mentioned it, that it's obviously the money, if you're using a life insurance policy, a retirement benefit, some other estate planning document, that you need to name the trust. And I think it's important for folks to know that sometimes these trusts are in a will or sometimes they're in another trust. So you really need to make sure that you get help with those beneficiary designations so the correct trust is named, so that the money goes where you want it to go.
And can I add one point to that?
Absolutely, absolutely.
It's something that we see a lot here at Washington Trust, and I just want to kind of highlight it for our listeners and our attorney listeners and our financial partners, is when you're working with your financial institution, you're looking at your beneficiary designations, whether that be a pay-on-death account or particularly I'm speaking right now to an IRA account, and you see the beneficiary of that IRA being any trust, and in particular a special needs trust of any sort, that you're talking with that client about, have you reviewed with your attorney whether or not this particular trust is drafted appropriately to hold retirement assets? Because there can be significant tax disadvantages to doing that if the trust isn't drafted correctly.
And I love taxes, so that's my cue to come in. So we actually have had something very recently about this, and it's not just the beneficiary designation, but if you have a trustee, like for example, if we were the trustee of the trust, you could ask us to look at it, because depending on who's named, Lisa mentioned that on a third-party trust, for example, you could name whoever you want to take the benefits after the special needs beneficiary dies. However, if you name certain people or certain entities, like charities, to take, you could create a real problem for yourself with respect to RMDs and taxability and things like that for IRAs. So it is important to have people who know, who are expert, who know what they're doing, either your lawyer or your financial advisor or your trustee, to review these things with you, especially since there's been so much change in the last year and a half, 2 years, not just with COVID, but with the legislation relating to retirement accounts. And I don't know if Lisa, you want to, Lauren, did you have something to say on that? Go ahead.
Yeah, just like Kim was saying, to make sure you're working with your professionals in the area. That I always stress to our clients that if you're setting up a special needs trust, make sure that the attorney you're working with can give you examples of multiple families at multiple asset values that they've worked with. They don't have to give you names, they don't have to give you private details, but you want hard examples to make sure that they really do this and they're not dabbling in it, because this isn't an area to dabble in. And the second thing is making sure, just ask them if they're familiar with the POMS, which is the federal standards that really drive special needs planning. If they look at you blankly when you say the word POMS, you might want to get a second opinion on your estate plan. And as Kim was just saying, especially if you're planning for retirement assets into any kind of trust, and especially special needs trusts, talk to them about whether or not any of their trusts have ever inherited those assets and what the results were, because you really want to take a hard look to make sure that that plan is appropriate. And final point on this, when you're meeting with your wealth advisor, I know our people at Washington Trust do it every year, review your beneficiary designations every year to make sure that they're correct, and then have that same conversation again about, did you amend your trust? Is it still appropriate to hold these assets? We see a lot of missteps there. I used to see them all the time when I was practicing law. So just want to put my little warning out there.
Yeah, absolutely. And Lisa, I don't know, I think we covered both. I think we covered the difference between first and third party trusts, who can fund them, where the funds can come from, and beneficiary designations, additional funding. You mentioned
conservatorships. I'd love a little bit about conservatorships if this is a good time.
Well, before we do that, because I wanted to talk about the soft part of SNTs too, which we didn't really talk about, which I would bring Anna back into the conversation. But before we do that, one thing we didn't talk about is, and I know you did mention it, maybe it looks like you set up an SNT for a child when they were young, for example. What if things go along and the SNT is no longer needed? What if, God willing, everything works out and you don't really need it? SNTs, are they revocable? How does that work?
Are you asking me or Lauren?
I'm asking you first, Lisa.
Okay, very good, because I know that Lauren is quite the expert at this as well. So the self-settled trust is irrevocable, because keep in mind, the only way that you're going to be able to revoke this is going to be with the Commonwealth's okay. The Commonwealth is entitled to notice of this. And sometimes there is reporting requirements to Social Security, to the Social Security Administration. The Social Security Administration is watching and knows if you have used Medicaid, which we know here in Massachusetts as Mass Health, towards the funding of various services, supports. There's many different services, supports, Medicaid, and so if you are looking to revoke or end a special needs trust that's a self-settled special needs trust, you can't do that without first paying back the Commonwealth. The Commonwealth has permitted you to establish this in the first place because you have agreed to have a payback provision. And so these trusts are irrevocable. And I have not ever revoked one. But I do know that when I establish these, if there's any communications that I need to have about any outstanding sort of outlying issues, such as the need to revoke, I would contact the Social Security Administration. And I anticipate they would send me their letter. I've received estate recovery letters many times from many clients saying, you know, we've paid X number of dollars during the lifetime of this trust. We'd like to have it reimbursed. My suspicion is that if you wanted to revoke a special needs trust and pull the funding out, then, and if it's a self-settled one and it's irrevocable, my suspicion is that you could do it only after you get written authority to do so from the Social Security Administration. I wouldn't try revoking it without that because there may be a debt that needs to get paid.
Yeah, and for third party, I guess it depends on whether it's funded or not, Lauren. Is that where generally?
So you can do a third-party trust that's revocable while you're alive, while the person funding it is alive, right?
Right.
But the grantor is alive. But once they pass away, it would move to irrevocable status.
I see.
But I do want to put a caveat on that, because there always is, right? You can make your third-party special needs trust irrevocable upon funding if you're trying to move money out of your estate.
Oh, right. Okay.
So you could have it be irrevocable, fund it to move money out of your own taxable estate, which I know we're not getting to estate taxes and probate and on.
Right.
But just know, asterisk, if you're the kind of family who's looking to move money out of your estate, you could do that by funding a third-party special needs trust. And I think you're going here, Kim, so I just want to finish the thought. Is, you know, we talked about how, what if the individual doesn't need, it turns out they don't need a special needs trust in the future. And what I really look for when, you know, if I'm working with an attorney that's drafting a trust and they're sending it to us, and it's an individual that's on the line, we don't know whether or not they're going to actually need governmental benefits. We don't know whether or not there's going to be an issue with putting cash in their hands. So that's really what we're worried about here, right? Yep. There's issues around housing and, you know, possibly reducing SSI, but what we're really worried about is whether or not we can put cash into this individual's hands at the end of the day. And if they don't need governmental needs, do we want to put the cash in their hands? If we do, what you might want to consider is you're drafting a trust for that individual that has a toggle in it that it's not a special needs trust up front, but the trustee in their discretion can hit the switch and turn it into a special needs trust. So you want to consider when you're working with your drafter if you want to have that flexibility in the document.
Yep, and I think flexibility and not being cookie cutter and realizing that particularly for individuals on the spectrum, you need to have sort of the trust needs to relate specifically to that person and have built-in options for flexibility because you don't know where things are going. And I think, Anna, you were talking about that right at the beginning, you know, and I think if you could talk, because I think this is going to be helpful for us, Anna. I didn't ask you about this at the beginning, but you, at the Wolf School, you guys do a plan for students, but I think the plan that you do for students and that you update kind of is similar to what we should think about as we're drafting special needs trusts for children and even young adults on the spectrum. Could you just talk about that very briefly, the plan that you do at the Wolf School?
Yeah, and I think Lauren had mentioned it at one of our meetings in terms of having a letter, you know, coming up with a letter sort of about the trustee, which I loved, and I connected that to something that we do at Wolf, which is sort of our profile on a page, you know, so to speak, but, you know, about each student, and that is sort of like a living document that goes from year to year, to teacher, that we add to and we change and we update and modify, and it really just, you know, is a living log in a sense of where things are at that moment in time. What are the child's, interests? What evaluations have they had? What, names of their friends, their hobbies, foods that they love, foods that they hate. What are some of their triggers, that gets them, that get them really upset? What's their favorite book? What things are really challenging for them? So it's everything. It's really just sort of on one sort of page, which then becomes multiple pages over the years, just a sort of living document about the child. And I just think it's something that it's flexible, we can adapt it, it changes as the individual child changes, and it has, really key pieces in there that, are accessible to anyone that sort of is working on that child's team that wants to learn more about the child or needs to learn something in the history of the child, or just kind of where that child has come from and past school experiences. I mean, it's really just everything you can think of sort of in one place that provides a really good resource as the child moves from year to year as they get older and older.
Absolutely, and I think we can do a letter of direction, things like that are, it's not binding, but it's very helpful to help us figure that out. And I think in addition to the discretion that Lauren was talking about where you flip a switch, there's some other things we might be able to build in, like estate planners, and Lisa and Lauren can talk about this.
Sure.
What if a child, gets a full-time job or graduates from college or things? Maybe you can build things in there, into the trust that will grow with somebody. Do something like that. I don't know if you want to talk a little bit about milestones or payouts or things like that. There's a lot of ways that you can build flexibility into a special needs trust.
Before we answer that, and I want to answer that, Cameron, have Lisa answer, I just want to follow a little bit about what Anna was just talking about, because I can imagine there are people out there wondering, why would a corporate trustee want to see this letter about who my kids' friends are? Why would they care? That's a great point. And I want to be clear about why we care. So if you have a trustee who's is trustee of an irrevocable first or third party trust, what you're saying is, you trustee, I'm trusting you to handle this trust for the benefit of my child. And the more we know about your child, and this is your child when they're 12, if something happened and you were incapacitated or passed away, or this is your child when they're 60, but the things we want to know and the more information we can get are things like who they trust, who did your family trust, what is this person's hobbies? Like we talked about earlier, especially with an ASD individual, a hobby is akin to a therapy. Mm-hmm. So, I know we have a beneficiary who goes through an iPhone every year. That is his lifeline. And we totally expect that. And we would never think, oh, is he doing something odd with his cell phone? Is somebody taking them from him? We know that this goes on. I think a lot about what we learned from the pandemic, that before, what I wish I knew now is there a certain food or drink or brand that this person relies on as their food source and made sure they were stocked up, or that they had it ahead of time in case it ran out during the pandemic. So those are the things we want to know. That's kind of why when Anna's talking about, we do this at the younger level with the kids, us knowing that when we're trustee, the more information we can get and we can understand, the better we can serve your child in the future, and the more comfortable they'll be with us as trustees. So I just wanted to bring back around why that letter was so important.
No, and that's a great point, because, and I think this is one of the things we're trying to get at is, the parents or other guardians of this child, and Lisa had mentioned this earlier, even when that child is an adult, are doing these things. But there comes a time when either disability, illness, age, or death, where you can't be that person anymore, and you want somebody who, if that issue, concern, challenge lasts for the entire life of the person you love who has ASD, you want somebody else to be there doing that, and that's what these trusts can do. They're not just like here in 2-4 and therefore, it's not all legalese. It's also about maintaining the sort of standard of life and support and all that kind of thing that you would have done yourself if you could do it forever, doing it, putting that plan in place now so that it can work and be there when you can't. And I think that's the flexibility too. Like parents will and guardians will change as the person they love change. And I think that when you have a written document, you need to build that flexibility in. So that's what I was going to ask Lisa, if she can talk a little bit about how you build in flexibility to address the fact that somebody who's on the spectrum changes over their lives, their needs change, maybe they need more, they need less. How do you, what's a few ways that you might build flexibility into the document?
Sure. So I'm going to pull from a few things that we just discussed, actually, in answering that question. You had used the word incentive. You'd used the word milestone. We looked at irrevocability of trusts and third-party trusts in particular, and we're talking about flexibility and goal setting so that individuals can have a productive life and an enriched life and a good life long past their 18th birthday. So we want these trusts to have the flexibility to move with them and to change as they change. We may realize, in terms of the funding of a third-party special needs trust, we may realize that a trust that we prepared for a child is not as applicable anymore as maybe it was, or perhaps people listening already have some third-party trusts established and they're going to get some ideas from our presentation and say, oh, I wish I had done that, and now it's irrevocable, maybe it's too late, you know, or whatever may be needing to be enhanced. Don't worry, it's not too late. One of the strategies that can be used, because these trusts do become irrevocable, is to establish the trust but not fund it right away. And if you need to enhance the trust or refine it or rewrite it, you can supersede it, and it's never been funded yet. You know, it's a trust vehicle without the funding. And so in terms of the fact that, you know, you're wondering whether it's revocable or irrevocable, if it hasn't been funded, you can supersede it with something else. And so along those lines, now moving along to the words incentive and milestone and the things that we want to put into a trust so that individuals who are on the spectrum have enhancement and enrichment in their lives, we can insert incentives and milestone achievement markers into these trusts so that, for example, we might say that upon the attainment of a certain type of life skill or upon proof of participating in certain treatment goals or establishing and repairing relationships or safety goals, anything like that, there will be a special type of distribution from the trust. Now, it can't necessarily be cash because we can't be putting cash, taking cash out of the hands of the trust, if you will. It's not literally hands, but you can't take the funding out and the cash out. But what you can do is, for example, use the trust to fund the purchase of certain items as a reward. So you can have a reward-based system. I had one client in particular who had a trust established for a gentleman who was 19 years old, and they had certain milestones for him, behavioral milestones and conduct-related milestones in this special needs trust. And each time he was able to comply with certain rules and requirements that related to maintaining himself and his family and the environment safely, they were able to purchase more gym equipment for him, and they ultimately they created a gym in the basement for him with whatever equipment he wanted, and he had a wonderful, gorgeous gym down there because he was so motivated to manage his safety as a result. And so that was one way that the trust was used flexibly. Another way is sometimes, unfortunately, there is the need for milestones to keep people free from the criminal justice system and to manage behaviors that way. And so these incentive trusts and milestone trusts can assist in coming together with a full multidisciplinary kind of incentive program where you've got, let's say, a probation order that has to be followed, and it's recited also in the trust. You can actually have the trust state that there will be milestones created in a memo from time to time, and that there'll be further documents about the types of milestones, but it contemplates, as an incentive trust, it contemplates using incentives and milestones and a reward system.
Now, that's really interesting. I just realized, though, as you were talking, that even though we were talking about special needs trust, I don't think we mentioned the restrictions on distributions, like what you can and can't buy, why you can't give people cash, and also the ability to use sort of like a payment debit card. Could you just talk briefly about that, Lauren? Because
yes.
I think we skipped over that in our excitement about other stuff.
I was thinking about that when I was like, oh, we should have stocked up on orange soda. But, which, by the way, don't stock up on orange soda. So with the special needs trust, the big thing is that in order for someone to qualify for government assistance for specifically SSI, we need to make sure that, A, their income is kept below a certain amount, which is why we don't put cash in their hands. Now, even if it wasn't a special needs trust, there's good reasons not to put cash in people's hands. Mm-hmm. But specifically for SSI, we do not put cash in people's hands because it could be accountable resource, which could disqualify them. You also are not supposed to purchase things like food. And the other big one is shelter. Now, what happens? A lot of times you have a special needs trust that wants to buy a house. You want to make sure that the home over this person's head and there's enough funds to buy a house and last for them for a lifetime. What does that look like? It doesn't eliminate SSI. It decreases it. Mm-hmm. So I just want to put that out there because a lot of people are always worried about housing. But we want to make sure that any of the health care coverage they're getting through the state, that we're not putting cash in their hands so it's not too much of a accountable resource, and that we're making sure that we are working with their social worker or with their caregiver to make sure that if we're doing a distribution related to housing, that it's not going to affect their aid, or if it does affect their aid, that we're comfortable with that. Mm-hmm. You know, we have had trusts that, for lack of a better term, we've blown up and said, okay, this is actually an $8 million special needs trust, doesn't need to still be in existence. And should we go through the process with the court to blow it up because this person is doing so well and start over again and have it just be irrevocable as opposed to a special needs trust? So you need to be having those conversations and try to work out what's best for your individual. As to cash in hand, there are two other methods for distributing money to get cash in hand, or a good proxy for it for special needs trust individuals, and one is ABLE accounts, which they're set up per state law, and those can be funded with money from the special needs trust at $15,000 per year. So we utilize those that work like a debit card, and they aren't monitored on a daily basis for inappropriate expenditures such as food. Just all expenditures are sent to the IRS and Social Security every year, and if they may decide to audit it, you just want to make sure the individual has records. So you have ABLE accounts, $15,000 per year. If it ever gets above $100,000, it's a accountable resource. So just check marks to keep that in mind. The other tool we use as a proxy for cash in hand here at Washington Trust is there are certain credit cards that we can use that are sanctioned by the POMs, listed in there, that we're able to turn off things like grocery purchases, turn off things like McDonald's. But then, other than that, we can fund it at a certain amount per week, per month, depending on the capacity of the individual, and they can use that stores as they would other things. And that gives a great sense of flexibility and independence to the beneficiary.
Right. And as we've been talking about this whole time, it obviously depends on who the person is, what they're capable of, but you can sort of give them, and how you fund it and what you allow them to buy does give them, you can tailor it to the person, to where they are on their, on the spectrum. So
and it can be very creative. I should chime in and give a quick little vignette of one of the ways that I was able to provide a reward for milestones achieved and a way to get a real value for the individual out of this trust. I was administering, in my capacity as trustee for an individual, a special needs trust. She was the recipient of a large personal injury settlement, and I was administering it for her as her trustee. And as a reward, we enabled her, my firm and I enabled her to go select the puppy of her dreams, and we actually established a retainer account at the vet so that and provided her with whatever she needed. So in terms of enrichment, rather than handing cash to her, we enabled her to have, you know, all expenses paid for the pet of her dreams. And it turned out to be just terrific. And she could go to the vet whenever she wanted. Food showed up at her doorstep. It was all very well managed, and she felt very comforted by this.
That is an awesome story. And I will say we do a lot with pets at Washington Trust and our beneficiaries. We also do a lot with vacations at Washington Trust with our beneficiaries as rewards and other things. So, but yes, we do a lot with pets, and that is awesome, Lisa.
And vacations, that's a beautiful thing, too. We do the same thing at Burns & Levinson. So when we're administering a trust, we might send the individual and a caregiver or two to Florida or to the Cape for the summer. So absolutely, we are exactly on the same wavelength in terms of finding creative, enriching, and truly enjoying ways to use that trust. You know, we never want those funds just to sit there and not be used. These are there for the enjoyment of the individual, and it's really up to the trustees to be very creative and to really keep the needs and desires of the individual in mind. And I'm delighted that both of our companies are able to manage that with such finesse.
Absolutely. So I have two technical things before, if you can believe it, we're only a few minutes before the end of our webinar. So I know, Lisa, we were going to talk very briefly about order of operations with respect to spending. Which trust do you spend from first? We also got a question about, in the case of divorced parents, would you create two special needs trusts or not? So could we answer those two questions, and then we'll go to sort of our wrapping up and then see if there are any other questions?
Absolutely. Let me start with the two special needs trusts in the issue of divorce. There's no reason why not. I think it makes a lot of sense. When people are divorcing, they need to disengage. And if you have one special needs trust, we're talking about third-party special needs trust anyway, you know, established by the parents, the divorcing parents, for the benefit of their shared child, it does make sense to have two separate ones. You know, the value in combining it might be that you have better investment power, and that's something that Washington Trust can do. The greater the assets that they're managing, the greater their investment policy, investment abilities, you know, and potentialities. But there's no reason why not to have two other than your spending power for the purpose of investment. And the advantage is this. When you've got a special needs trust, you've got to think about who's going to be trustee. Naturally, both parents are going to want to have control of how those assets are spent. So those parents are going to want to both be trustees. And if you're trying to disengage as a married couple, especially if you are disengaging in part because the decision-making that was related to the child who's at issue here, the child with the Autism Spectrum disorder, if that formed part of the underlying reasons that the marriage came down, then the last thing you want to do is have those two parents try to navigate expenditures out of a trust for the child, because you're going to hit stalemates constantly, because there's always going to be one parent saying do this and the other one saying don't do it, and so because that's what took it down in the first place. So what you want to aim to do is to have two separate trusts in that situation, and there is no reason why not. On the other hand, if parents do get along and they can make these decisions together and they can serve as co-trustees, or if one parent is willing to defer and let the other parent serve as sole trustee or trustee with, let's say, Washington Trust or another professional trustee, then there's no reason why not put it all into one trust, so that a company like Washington Trust is able to make the best and most robust investment choices. Kim, there was another question you wanted me to address. The first one. I started with the second, and now I can't remember the first.
Yeah, absolutely. I just want to follow up on one thing you just said. I'm going to let Lauren follow up because one of the main reasons why we talk about having a professional trustee is something that you just said. So I want Lauren to follow up on that.
Right, and I pointed at Kim, so I had a comment. It wasn't that one, but I will take this one.
Okay, sorry.
Usually our brains work the same, but not right now. So exactly what Lisa was just talking about is, and we didn't talk about today, is the value in having a professional trustee. And it's for this exact reason, is that, you know, even if mom and dad aren't fighting, even if they're not getting divorced, the fact of the matter is your child is going to be older, and possibly the parent doesn't want to be the one saying no. Mm-hmm. The parent might not want to be telling their 30-year-old child about this trust that was funded by grandma and grandpa that you can't have this money to go to Cancun with your best friend. And you might want to put that on a professional trustee as a neutral and not harm the family relationship. Or, at least was saying, if they were going to fund a trust together, you might want to just have a professional trustee and not have it be mom or dad in a divorce situation, again, to neutralize that issue. The other piece I wanted to mention, Lisa, about why we have two separate third-party special needs trusts in a divorce is remainder beneficiaries. You may want to have different remainder beneficiaries.
Absolutely, that's a great consideration because mother might want to have the beneficiaries be one class of people on the death of the child, whereas father might want it to be a different class of people. So, you know, Lauren, this is why we do these presentations together, and I always learn from all of you. You know, it's just a wonderful thing, but that's an excellent consideration.
Yeah, and I was going to follow up on that, Lisa, that if mom and dad did at first draft their two separate third-party special needs trust with similar beneficiaries and didn't change them, but they had the exact same, you can always also draft in a doctrine of merger clause so that your professional trustee can combine them at a later date if they needed that spending power if the remainder beneficiaries remain the same. Yep. So we have options there.
That's great. Yeah.
Very good. I do remember your first question now. Do you want me to address that? It's a strategic question of which trust to use first. Exactly. And this is very important. And we promised that we would get to this before the end of that hour, and here we are. So here's the catch to these trusts. And so for all of the registrants who are listening right now and who are thinking about whether to have a self-settled trust, known as a first-party trust, or a third-party trust, and for those who might have both, what you want to remember is that the self-settled trust, the first-party trust, is the one that necessarily must have a claw-back provision. It's going to have a pay-back provision, meaning that from the first-party trust, from the self-settled trust, the assets in it must be used to reimburse the Commonwealth for all expenses that the Commonwealth paid to support the care needs of the individual who has the autism spectrum disorder, the beneficiary of the trust, whereas the Commonwealth does not take reimbursement from the third-party trust. So for this reason, use the first-party trust first. Use that self-settled trust to fund the pet and the veterinarian services, to fund the vacations in Florida, to fund the many different enrichment activities, membership to different, the arts, to cultural different areas, and whatever it is that's needed, special mechanized devices for the individual that perhaps are needed. Whatever it is, use the first-party trust first, because you can exhaust that one first and thus wipe out the estate recovery obligation, because remember, you don't have to give the Commonwealth reimbursement. You don't have to deal with estate recovery for a third-party trust. If anybody has any questions, I know these issues, many of what we discussed was very technical. Feel free to call any of us afterwards and we can further explain it.
Absolutely. So I'm just going to wrap up right now and then we'll open up for questions. So we had some key takeaways that we had wanted to share with everybody. And I think you can see by the panel that we have here that building your team of experts is very important. So whether those that's going to be medical, educational, financial, legal, trustees. Get the group that you trust that works for you and your family. Start bringing them in early. Let everyone get to know them. I think that's very important, especially in this instance, because the folks that are on the spectrum. It's important that they feel comfortable with the people that you pick, that they know who they are, that they know a trust exists, and they know what it means. It's very important to do it early, and that goes to our second set of takeaways, which is plan now. Establish a vision for the person. Keep it centered on him and her. You've heard a lot of information today about little anecdotes and things about how things were done that were unique to the person. And when you think of trust, you probably don't think of, buying puppies or aquariums or going to Disney World or whatever. But that's exactly what we're talking about, is it uniquely focused on the person and meeting their specific needs. And then that's our last takeaway: unique, flexible, and centered on the person with autism spectrum disorder. There's no cookie cutter. You can't get this off the shelf. This is something that you need an expert who knows about special needs trust. You need to make sure that they know the person you love who is on the spectrum, or your client who's on the spectrum. You need to know who that person is, and it has to have built-in ability to grow and change the way they're going to grow and change. And so I want to thank very much Anna and Lisa and Lauren. I thought this was very informative, and I really appreciate you all bringing your expertise to the table for our listeners today. And if anybody has any follow-up questions that they'd like to ask Anna, Lisa, Lauren, or myself, we'd all be very, very happy to provide you with any additional information or answer your questions. Thank you.